air or clean water, but doesn't specify how exactly we should get clean air or clean water. Then it will defer to these agencies like the EPA and the environmental scientists and the experts who work for that agency to determine the laws and guidelines for how we can get to that goal. Now, these agencies, among other functions, are the regulatory bodies upon which we rely in nearly every aspect of our daily lives. The Environmental Protection Agency regulates pollutants. The Department of Transportation comes up with safety standards for cars and highways. The U.S. Department of Agriculture makes sure our food is safe. The FDA determines which drugs are available to us. OSHA and the Department of Labor keep workers safe and protect workers' rights. Experts at the Department of Health and Human Services help our healthcare policy adapt to emergencies, changing technology. It informs healthcare decisions that have an impact on more than half of the country's population. Chevron deference is rooted in the belief that agency experts and not courts have subject area expertise to inform and implement laws with the appropriate nuance. Now, conservative groups have for decades been working to undo Chevron in order to limit agency power and to limit regulatory authority. For instance, back in 2018, then White House counsel to President Trump said it outright at the Conservative Political Action Conference, quote, "There is a coherent plan here where actually the judicial selection and the deregulatory effort are really the flip side of the same coin," end quote. On Wednesday, the conservative majority on the Supreme Court appeared exceptionally sympathetic to the fishermen's case and increasingly hostile toward the Chevron precedent. If the Supreme Court overturns Chevron, as it appears poised to do, it would drastically shrink the power of federal agencies to regulate much of anything at all, which means that private businesses and corporations may have more ability to challenge and violate regulations like environmental regulations, food safety regulations, trading and financial regulations, just to name a few. The knock-on effect of overturning Chevron is difficult to calculate because it has the potential to have an impact on nearly every facet of our government and of our daily lives. Joining me now, Melissa Murray, professor of law at NYU, co-host of the Strict Scrutiny podcast, and an MSNBC legal analyst. Melissa, thank you for being with us. I appreciate having you here. I think we have to start with the understanding of why regulations exist and whether they are valuable or they are onerous. And these kinds of arguments make it seem that it's black and white. So it's entirely possible we have too much regulation in some cases or that it's not appropriate regulation. But for many people, regulation exists as a protection that your water is not polluted, a protection that your air is not polluted, that your meat is not spoiled when you buy it from the shop, that your paint doesn't have lead in it. So how do we think about this ongoing multi-decade effort to crush regulation?
No, it's a terrific question. And as you suggest, Ali, the fact of the herring fishermen here is something of a red herring, because this case is not necessarily about mom and pop fisheries, but rather about the deep-pocketed corporate interests who have been hostile to regulation for some time. And so, as you say, we live in a regulated environment all the time. It's what creates a safe environment for all of us. The air that we breathe, the water that we drink, the food that we eat, the things that we put on our face, the drugs that we consume, all of those things are subject to federal regulation. Agencies staffed by experts who know what kinds of particulate matter should be in the air and what kind should not be, how much of that particulate matter should be in the air and how much should not. All of those things rely on science-backed, evidence-based expertise that agencies, as opposed to the legislature, has. So Congress can write a law, but the law is often open-textured and broad. Congress can't see around corners, so they're anticipating things that will come up in the future, but they can't really specify what they are. And so they write these laws and they delegate considerable authority to federal agencies to determine how to actually implement the law with regulations. The problem for these corporate interests, though, is that these regulations often make it more expensive for corporations and corporate interests to operate. So if you are operating a workforce where OSHA has regulated and say you can't have large things hanging overhead because it might be a threat to the safety of your workforce, well, you've got to figure out how to operate without all of those things. And perhaps you have to take more expensive steps to make your workplace safe. That makes it more expensive for you to operate. Similarly, if you are a large factory and the EPA says you can't emit your waste into the water stream, you've got to figure out another way to shift that off. And that becomes more expensive. So these corporations are really hostile to the prospect of regulation because it makes it more expensive for them to operate and more expensive and less likely that they will have the kind of outsized profits that they seek.
It is useful to understand how regulations come to be. Some of them are common sense. Some come from investigations or tragedies or things like that. Some come from lawsuits where things happen and you realize, oh, there's a pollutant here or there's something that's causing people to get sick. The way these arguments are framed makes it seem like, and it started with Ronald Reagan, it's this idea that it's all this nefarious effort by government to be bigger, control more, take more of your taxes.
Well, that's the irony, because this case, Chevron, was decided in 1984, and a conservative court with many conservative justices all decided that it was appropriate in that situation where there was an ambiguous statute to defer to the Reagan administration's EPA in the interpretation of this federal law and the regulation resulting from it. And it just so happened that the Reagan administration's EPA was not so great on regulating industry. So it was a pretty toothless regulation, and it was cheered by conservatives who wanted a more regulated environment. The problem has been, of course, is that the Reagan administration wasn't in place forever. We have these oscillating political winds. Sometimes there's a Democratic administration, and regulation might be more forceful, more in keeping with environmental thinking about how to make a safer environment. And then it becomes more expensive for corporate interests. So they basically decided that now that they have a federal judiciary stocked with movement conservatives who have antipathy for this kind of regulation, rather than deferring to agencies, they should just let courts decide this when statutes are ambiguous. And that has precipitated the antipathy for Chevron deference. And that's what's brought us to this moment at the Supreme Court.
So one of the things that the justices have to consider is that if they overturn Chevron and effectively diminish or take away agency power, what's the alternative? What happens then? Because if it has the effect of eliminating the regulatory authority of all of those agencies that I had on the screen, what happens? There are hundreds of thousands of regulations on the books. Do they go away? Does Congress have to take them all up? What's the alternative?
Well, I think there are two scenarios. One that was contemplated at oral argument was that this would shift back to Congress to make these decisions. But as we know, Congress is famously polarized and sclerotic. Not much of a chance that Congress is going to be able to put out the kinds of regulations in enough time and at the pace that's needed to address some of these issues. It's also not clear that legislators have the expertise to actually do this. So imagine Marjorie Taylor Greene making decisions about particulate matter. I mean, again, some of these questions require deep-seated expertise that the average legislator doesn't have. So then that leaves the federal courts. So again, rather than deferring to agencies, we might understand this entire case as a power grab for the federal courts. The courts will decide when a statute is ambiguous, and then will decide on what the most reasonable interpretation of the statute is. And if you have a federal judiciary that has been stocked with movement conservatives for a long time, well, you can imagine where this is going in terms of the prospect of a regulated environment.
Melissa, this is an ongoing issue. We've talked about it a couple times. We're probably going to have to talk about it several more, but appreciate the clarity that you bring to it. Melissa Murray is an MSNBC legal analyst, a professor of law at NYU, and a co-host of the